Welcome friends, Namaskar and Suswagatam to our Saturday uh, version of the legal words of wisdom, that is Nyay Gyan Ganga, which we beam on our social media channels of Virat Hindustan Sangam. And being a Saturday today, we have another episode. Today we will be discussing consumer protection. How far should the law go? We have, as usual, Dr. Subramanian Swamy and Dr. Venkat Iyer, who will be discussing with another guest friend of ours, Advocate Ajay Jagga. Advocate Ajay Jagga practices in the High Court of Chandigarh as well as in the Supreme Court, and he has been in the forefront of numerous, I would say, consumer rights, local issues on GST, preservation of heritage furniture and structures, and in lot of causes where directly the common man is involved, and he's very popular in Chandigarh. And we welcome him to our show. And also, as you know, Dr. Venkat Iyer is based in UK. He's a lawyer by profession and has been a barrister, mediator, and has been associated with numerous activities around the globe and has been in academics. And he has been kind enough to start this episode, which is now on the 20th episode on legal words of wisdom, Nyay Gyan Ganga. And we have been trying to educate the people on the importance of legal knowledge and how to face various types of issues when confronted with the law. And as you know, Dr. Swamy has been in the forefront, not being a lawyer, but being an economist, but has been fighting for his own PILs in the courts in various levels. So with this today, we'll be discussing the consumer protection. How far should the law go? Almost everybody is a consumer, and they have to deal with suppliers of goods and services on a regular basis. What protection do consumers have under the law? Are there any remedies when they receive shoddy services or become victim of cheating or fraud? Can the law bring businesses to book for bad behavior? How user-friendly are the procedures for obtaining redress, including compensation? Should the provider of professional services like lawyers and doctors come under the purview of the consumer protection laws? These are some of the issues that will be discussed in this episode. I also have to mention to you that Advocate Ajay Jagga of Chandigarh has recently published a commentary or a booklet on the Consumer Protection Act, and perhaps he will, in his talk, tell us about this, the Consumer Protection Act 2019. This is the booklet he has written, and it is a very useful booklet for the common man and for everybody to understand. So with this, I would now request first Dr. Swamy to have his introductory remarks, then Venkat Iyer will speak, and then Ajay Jagga will speak, and then we'll have a discussion. I also wish to thank my co-host Ramesh Swamy for helping us in this program, and our technical team led by Ashish Shetty, Vishal Mehta, Ishwar Iyer, Tejas, Rakesh Gadgi, and Swaminathan from Chennai for their regular inputs and help to put the entire program together. So with these opening remarks, it's over to Dr. Swamy for his introductory remarks, and then Venkat Iyer and Ajay Jagga ji. Thank you. Over to Dr. Swamy.
Yeah. Thanks, Jagdish. It's a very important topic because we are all consumers in the final analysis, and therefore, something or the other, and we don't like to be cheated. We'd like to know what we are getting is pure, unadulterated, and so many other things which any common person is interested. And there should be a law. There was a law, and now we have a well-developed law. And we got two very prominent lawyers. Jagga is coming for the first time here, but he's been a tremendously popular lawyer because he's taken public interest causes so widely that practically everybody knows. Whenever I mention the name about our Ajay Jagga's name, they say, "Oh, the man who filed the PL on this and that," and he's most famous recently for having stopped antique furniture from being exported from Haryana. Now that's how esoteric he gets also. So we are very pleased to have him. He's also with us in the VHS, and he has been a long time associated with me. I mean, I've been easily 2 decades, and he has arranged my programs in Chandigarh, which have been highly successful. So, with that introduction, of course, I don't have to introduce Venkat because Venkat has been so popular on this series that he's very very known. I can't really do justice since he's already so well known on so many different angles. The question basically that I was concerned was that there has to be a punitive aspect, I mean, a punishment, and we have to see the categories are such that they should, being dragged for criminal purposes, there should be a just cause. I had been approached by doctors, and you see, doctors, that medicine, giving medicines, performing surgeries, they always carry an element of risk. And when something goes wrong, they blame the doctor. And then they go straight to that's how it used to be, go straight to the police station and file an FIR. And then the doctor gets summoned, and then the criminal proceeding starts, and the doctor has to hang around in court till his turn comes, all that kind of harassment. And I don't think that what is happening is that the number of people wanting to become doctors, especially things like surgeons, is dropping sharply. So I felt that you can include lawyers. They've not been included so far because lawyers can argue. I mean, they don't need to hire another lawyer. So therefore, lawyers know the law and lawyers can defend themselves. That's another area. But as far as doctors are concerned and categories like that, they should not be in the scope of the consumer protection law. I don't know whether the two luminaries of the judicial law profession will agree, who are here today to tell us their points of view. And I don't think I should waste more time and handing over to Venkat and Jagga to continue the debate on this issue as to what is consumer protection law.
Thank you, Swamy. There's hardly any day when most people do not assume the role of consumer and buy goods or services. And this is a universal phenomenon. A lot of the time, that role is performed on a voluntary basis, but equally, there are situations when people are compelled by circumstances to become consumers or customers. For example, when they need the necessities of modern life, such as water or electricity, or nowadays access to a telephone network or to the internet. In some societies, the choices for where a person can get goods or services is limited, as used to be the case in the former Soviet Union, and as is still the case in the remaining collectivist societies, such as North Korea, where the state has a monopoly over goods and services. The younger viewers of this program may not appreciate this, but India was not all that different for a while in the 1970s and 80s. If you wanted to fly from, say, Bombay to Delhi, your choice of carrier was restricted to Indian Airlines. If you wanted a telephone line for your home or your office, you could only get it after a long wait from the state owned and operated telephone company. You can imagine how stifling it must have been to put up with that reality. More depressingly, you can imagine how little protection people had against the provision of inadequate service or shoddy products. Because if there is no competition in the market for goods or services, there is no incentive for the monopoly provider to offer a good service. Mercifully, all that is now history, and there is now at least a half decent choice for most people under the liberalized economy that India has been operating since the early 90s. I say half decent because there are still many areas of business and commerce where real competition is lacking or where choice is still limited. I do not have the time to embark on an analysis of why that is so, interesting though such an analysis would be, but I would simply refer you to ponder the implications of something called crony capitalism, about which you have been hearing a lot in recent years. There is another dark side to the discussion, and that is to do partly with insufficient education and awareness among consumers about their rights, and partly with inadequate or broken mechanisms for the enforcement of those rights, even if you are aware of them. My talk today is going to be slightly shorter than usual, and that is because we have, as both Jagdish and Swamy have said, another guest on this program who will be explaining to you some of the nitty gritty of the law on consumer protection in India. He's well suited to do this, not only because he has put together a book on the subject to which also Jagdish made reference, but more importantly because he's had, and I assume continues to have, direct practical experience of how the law in this area operates through his legal practice in India, an advantage that I don't possess. My aim, therefore, will be slightly more modest, to give you a wider perspective on the subject, to set out the basis for consumer protection laws, and to tell you about the various ways in which they can be made effective. I shall bring in some comparative perspectives as well, against which you can judge whether the Indian regime is satisfactory or not. First of all, when we talk of consumer protection laws, where do these laws come from? A short, superficial answer would be from Parliament. And there is now a very new law that the Indian Parliament has passed, namely the Consumer Protection Act of 2019, which replaced a law of the same name that had been in operation since 1986. But if you look deeper, you'll realize that consumer protection principles have strong connections with a range of legal subject areas such as contract law, tort law, and criminal law. And at another level, anti-monopolies law and even constitutional law. Among the issues that frequently arise are those of fraud or misrepresentation, coercion or unfair business practices, negligence, product liability, and so on. Generally speaking, in a capitalist or free market system, the law allows people to make voluntary bargains through contracts. So, if X agrees to sell a car to Y and Y is willing to buy the car for an agreed price and on other terms which both parties agree on without coercion or other factors, the state or anybody else will normally not interfere. But freedom of contract is not absolute, because if it was so, there would be abuse of it to the public detriment. For example, parties with superior bargaining power will unfairly exploit weaker parties. Some people will enter into transactions which most societies would consider undesirable, such as gambling. For those reasons, certain limits have to be put on freedom of contract. But the restrictions that can be imposed should not be too severe, because in that case, commerce will suffer. How to strike the right balance is a huge challenge for all societies, and that is where the democratic will, usually expressed through parliament, comes in. Which means that the line between acceptable and unacceptable consumer contracts is drawn differently in different countries. And don't forget that nowadays consumer transactions are also affected by other more general laws, for example, anti discrimination laws. If you're a shopkeeper, you cannot refuse to sell something to anybody simply because he or she belongs to a certain community. And that's where constitutional law comes in. Generally speaking, it'll be rare for societies that operate a free market economy to impose unduly tough laws on prices or fees for services, because that will kill enterprise. Instead, what such societies do is to protect consumers indirectly by, for example, encouraging fair competition. This is among suppliers of goods and services, by breaking up monopolies, and by introducing certain procedural protections in consumer contracts, such as providing for a cooling off period within which the consumer can opt out of a deal if he has second thoughts about the fairness of the bargain that he has got. But I would argue that no matter how well the consumer protection regime is structured or constructed, it'll be of no practical value if there are no effective enforcement mechanisms. By effective, I mean efficient, quick, inexpensive, and honest processes and procedures for disputes to be resolved. And that is an issue on which Ajay will, I'm sure, be able to speak at some length about the situation in India. The next point I'd like to make is that there are, in the area of consumer protection, many principles, and one of them is caveat emptor. What this means is let the buyer beware. This principle imposes an element of responsibility on the consumer. He or she cannot be irresponsible and start blaming the seller or supplier of goods or services when something goes wrong. But caveat emptor has its limits. There are certain things for which the law imposes a kind of strict liability, and certain others for which it only imposes a test of reasonableness. Let me give you a few examples from the UK. Under British law, no party to a contract can deny or limit their liability for death or personal injury. Which means, for example, that if you decided to travel on a bus and the bus company puts up a big board to which your attention is drawn before you enter the bus, and the board says the owners or operators of this bus will accept no liability if you die or are injured while traveling on our buses, then that statement will be of no legal effect whatsoever. If, on the other hand, the same company said something like, we will not be liable for loss or damage to your property while traveling on our buses, that statement will have to be interpreted having regard to the facts of each case, and only if limiting liability is seen by an independent judge as being reasonable. Now, only when that happens will liability be allowed to be either denied or limited. Such statements are called exclusion clauses or exemption clauses. Incidentally, there was a case decided by the Supreme Court of India just the other day involving loss of luggage by a passenger traveling on Indian Railways. And the case was decided in favor of the passenger after the court used what, in effect, was reasoning based on reasonableness. If you want to hear more about that case, I'm happy to talk about it during the discussion that will follow later. Another important principle is that an exclusion or exemption clause must be drawn to the attention of the consumer before he or she enters into a transaction. So, if the operator of a public car park puts up a notice to the effect that any valuables left inside a parked car is left entirely at the owner's risk, and that notice is tucked away inside the car park and made visible to drivers only after they have taken a parking ticket and entered the car park, that exclusion clause cannot be used against the driver. Ultimately, it's also a question of fairness, which the law cannot afford to ignore. I notice that there are frequent discussions, dare I say, controversies in India about whether certain professionals like doctors or lawyers should be brought within the purview of consumer protection laws, a topic to which Swamy mentioned, referred in his opening remarks. Generally speaking, these professionals are not subject to such laws, but that is not a hard and fast rule. In most countries whose legal systems I'm familiar with, professions like lawyers and doctors are subject to stringent regulation, firstly through bodies like the Bar Council or the Medical Council, respectively, and those bodies have strong powers to impose disciplinary measures against errant members of those fraternities. Secondly, it is not uncommon for such professionals to be also sued under the general law, especially the law of tort, for damages. Quite frequently, huge sums of money by way of compensation are awarded against, for instance, doctors if they have performed operations without due care or attention, and that is how it should be. But of course, in practice, those damages are paid by the insurance companies, because in all such societies, every professional has to take out suitable policies for indemnity insurance. I do not think that any such system would work in a country like India, at least not yet, because, firstly, as far as I'm aware, the practice of professional indemnity insurance hardly exists, certainly not in relation to lawyers. And secondly, and more importantly, with the broken judicial system that India has, the chances of any litigant victim getting compensation within a decent period of time are virtually non existent, which is a real pity. Perhaps Ajay will talk more about this in his contribution. I hope Ajay will also talk about whether educational institutions should fall within the purview of consumer protection law. Only last week, there was a case reported from Bangalore where a coaching class had to be ordered to pay compensation to a student who had failed to get the high marks that had been promised when she enrolled for the classes. There are a few more brief points I wish to make, and then I'll be done. First, that in this area, education and awareness are extremely important. Without both, people will not be able to assert their rights or even challenge unscrupulous or indifferent suppliers of goods and services. In this regard, the role of NGOs is important. For example, there is the Consumer Education and Research Center based in Ahmedabad, which has been doing good work for many years now. But you need to be careful about NGOs who use consumer activism for ideological objectives and engage in destroying the free market system. Equally, it is important for businesses to behave ethically and not simply focus on profits. The sad reality is that there are far too many unscrupulous businesses in India, including some which have the potential to cause grave harm to consumers. You might remember the reference I made last week to the manufacturers and sellers of contaminated drugs and to the book Bottle of Lies. And that is only the tip of one big iceberg. I'm firmly of the view that such businesses deserve to be punished most severely, but punishment is only possible with greater vigilance on the part of the public and an effective legal system. I think I've said enough, and so I'll stop here and let Ajay have his say. Thank you.
Ajay ji, please continue.
Yeah, thank you. To begin with, I must say that Lord Krishna has said one thing, that the only thing which is permanent on this earth is called change. And so is applicable to the laws, because the consumer law itself has been kept on changing from ancient India, and presently after 33 years the first specialized law came in 1986, and after 33 years we have another law. But go back to the ancient Indian times, I was just going through that even in those days, the Dharma Shastras, which is known as Dharam, also laid out certain social rules and norms which served as guiding principles governing human relations. The principles of Dharma were basically derived from the Vedas, and the Vedas were considered the word of gods, and thus the law was said to have divine origin, which was transmitted to the society. Even if we go to the times of Manu and we go to Manu Smriti, in the Manu Smriti also there is reference with regard to the consumer protection as how a seller has to sell the products and how he is to be penalized if he does some cheating, and then how the consumer is to be protected. From Manusmriti, when we go to Kautilya's Arth Shastra, there also we find that lots of issues with regard to consumer protection were taken care of in the Arth Shastra as developed by Kautilya. For example, if the goods were not sold at a particular place, including the crops, then there used to be a particular place where people could take their goods and sell those goods there under the supervision of a superintendent who used to first work out what are the goods, what is the quality, what is the quantity, what are the rates, and he also used to ensure that there is a limited amount of profit attached to it, because the growers or the sellers were not allowed to have as much profit as they want. There used to be a strong check so as to ensure that the consumers are not being exploited. Now, from Manusmriti, we came to Kautilya's Arth Shastra. From when both these things, Manu and Kautilya, after that, when we go to the Mughal rule, in the Mughal rule also there was a strong consumer protection law, and one of the kings during Mughal rule was certainly quite concerned about it, that was Alauddin Khilji. Because Alauddin Khilji has kept one minister in his cabinet who was dealing with the consumer protection affairs. And then he had appointed certain supervisors and inspectors in all fields, like one for clothing, one for food, one for crops, who used to verify whether the weights are being used properly, whether the weights are being stamped properly. So during Mughal rule also, this thing was there. After Mughal rule, then came the British rule. In the British rule, they came out with the Pan India laws. Those are known as like Sale of Goods Act, and one Mr. Venkat has also spoken about Contract Act 1872. Then we had Indian Penal Code, in which certain punishments were prescribed for adulteration, etc. And then we have Drugs and Cosmetics Act 1940. Then we have certain other agriculture produce laws, that how to sell produce and how to keep the prices in check. So all these laws kept on changing with the times, and what Lord Krishna said really proving true for all the times. When after the colonial rules, when after partition or after the independent India, suddenly we thought that these laws, people were going to civil courts for seeking small compensation for being cheated. So they thought a specialized law should be brought in, and Consumer Protection Act 1986 was brought in by the Parliament. And with that law, it was felt that many of the cases, virtually lands were sorted out in these courts, at least the small causes. Now, since the commerce, the transactions, the business has changed its shape, we have gone from offline to online. So there were lots of things which were not existing in the 1986 law. And that's why everybody felt that there has to be a new law which covers all the online transactions and not only offline. The first and foremost point is that definitions has been enlarged. The first definition which has been brought in section 2 is that earlier what used to happen when somebody goes to file a complaint, and in case he was not having the bill, the complaint used to get dismissed, because the consumer failed to put the evidence on record, and that was the bill. But now that has been done away with. Now, not issuing a bill in itself as a matter of a consumer complaint. So, if you buy something and the seller is not issuing you the bill, it is a matter to go to consumer forum. So, this first change has been made in the definition of unfair trade practices, that has been brought into unfair trade practice. Next unfair trade practice, which I am going to quote now, like in India or even otherwise in the whole world, discount sales are going on. If you buy any item through discount sales, you will generally find it is written very prominently: no return, no exchange, no refund. It is the common word pan India available. But now the law has also brought in as a unfair trade practice. And in fact, Mr. Shanta Kumar, when he was Union Consumer Law Minister, he made a notification that saying no to return, take back, refund is illegal. But unfortunately, as Mr. Venkat knows it, that awareness has not gone to the bottom, and that law was not known to the people. But now this unfair trade practice has been enlarged, and this clause has also been brought. Third is one of the very important amendment has been brought into the definition of the unfair trade practices. That is to maintain the secrecy of the data of the people. When you buy something, you give your name, sometimes you give your date of birth, you give your phone number, you give your address. And nowadays in the commercial world, we know personally that these data are being sold out to the
Yeah.
telemarketing people. But now this has also been brought into unfair trade practices. And anybody who comes to know that I bought something and my data has been shared can go and file a complaint. You also have to be aware that when people go to the petrol stations, they generally, whether go to Indian Oil or Bharat Petroleum or Hindustan Petroleum, they'll give you a small coupon attracting people that please fill this coupon and you will get a price. That's nothing, it's a bullshit. They just put your data, they take your data, they sell it to a telemarketing company. So next time you go to the fuel station, don't fill any chit. It's just nothing. It's just taking your data and selling you the data. And now as well, it has been brought as an unfair trade practice. About healthcare, this word has been deleted. Thanks to Dr. Swamy for bringing this change. Otherwise, this word was already there under Section 2, but now in the new law, this word typical healthcare has been removed from the definition of service. So it goes out. We have another medical concern to talk about it. Another very interesting thing in law is that we have been hearing about the public interest litigation. And one of the pioneers in this field is nothing less than Dr. Subramanian Swamy, who has taken, so many people or through PIL. But under consumer law, this is for the first time that PIL has been brought into the consumer protection law. And that has been brought out by way of a class action suit, or even if I am not a consumer, I can file a consumer complaint for the benefit of the classes or the masses. So PIL has also been brought it under the consumer protection law. It is under section 17A, and I think it was a wonderful revolution. I have done some certain complaint few days back. I'll just come to that when I'll go to that point. Now from there I go to that e-commerce transactions were earlier not there in the Consumer Protection Act 1986, and since the consumer were going through day and night for all the online purchases, so they were feeling little problems with what about the electronic transactions, because they were not covered. But now the new law has covered all the e-commerce transactions which you are buying, whether from Amazon or Flipkart, etc., etc. All are now covered, and they have no escape route. If they cheat you, they can be pulled up. And the government, not only this, even the Ministry of Electronics has also done a wonderful job. They have attached a separate rules for e-commerce, which will be attached to the consumer protection law. Because when I file a complaint under consumer protection law, and it is with regard to the e-commerce, then there are a separate set of electronic commerce rules, which will also come to the help of the consumers. Then further, there was a lot of problem with regard to the pecuniary jurisdiction, that where the cases were or complaints were to be filed. Now the complaints up to 10 crore can be filed right into the state commission. Up to 1 crore, you can file it in the district commission, and beyond 10 crore, you can go to the national commission. So earlier, people used to rush to the bigger courts for higher claims, but now that issue is gone, and up to 10 million, you can go to the district forum or district commission because the name is now has been changed. Apart from that, keeping in view, it's a good luck that these laws has come when we were probably somebody was knowing that COVID is going to hit the world, and now that's why the e-filing of complaints has been brought in, and that website is called e-dakhil. Dakhil means enter. So edakhil.nic.in is the latest portal, and in Chandigarh, our consumer courts has done a remarkable job by making those things operational. So now you can file a complaint sitting at your home. You don't have to go anywhere. And as far as the fees is concerned, in India, up to 5 lakh claims, which is the maximum, there is no fees. So you can simply go to the computer, type your complaint, and just press the button. It goes in, and the action has begun. So this is also a wonderful revolution in our country, the way we are going. Examination of parties through video conferencing has also been permitted. So if you want to examine somebody, apply for video conferencing. The courts will permit you, and the person can be examined on the video conferencing. Next is coming the revolutionary change in the law, and that is called the jurisdiction. Earlier, there used to be hell of a problem. You ordered something on a portal. That portal gave the order to Lucknow. The Lucknow person sent that order to Aurangabad. And when you received the goods were defective. If you go to the portal, he used to say, I have not supplied the goods. If you tell the supplier, he used to say, I am not the manufacturer. And when you go to Aurangabad, they say, gentlemen, the jurisdiction is in Aurangabad. Please go to Aurangabad. So people were a harassed lot. For example, Dr. Swamy had gone to Shimla. The students there, they purchased a ticket. They created a mess out of it. And the problem those students were finding was that they purchased a ticket from a portal, then it went to agent, and then it went to Air India. So the jurisdiction was a problem. But now 34(2)(d) says that the jurisdiction is not an issue. The complainant can file the complaint from where he resides or where he works or where the opposite party is situated. So it is absolutely free jurisdiction. You can go to file a complaint wherever you are. So that issue is also over. That will bring a much needed relief to the people of this country. Now we have another new concept called Central Consumer Protection Authority, CCPA. It is in section 10. This is a new concept. It is permitted to take suo motu cognizance, call for defective items. If they see something has happened, if they get certain news, they can call for investigation. They can send people behind bars if they don't follow the orders. So because in the past we had a big problem. People used to say this is a toothless tiger, the law. But now the toothless tiger is no more a toothless tiger. It has, extremely stringent provisions. Now comes the misleading advertisements. Every day in the newspaper, TV channel, everywhere, even on your phones, you are getting misleading advertisement. People are saying you buy my product, it will kill COVID germs. Who's killing COVID germs? Humans are not sure. Then how they're going to kill the bacteria of COVID on the floor or on your bathroom or your washroom. So all sort of these things are coming now into the market. Detergents, COVID killing. So for these things, a wonderful section has been brought out under the definition 2 subsection 47, that is the misleading advertisement in itself has a unfair trade practice, and it involves all the people. The person who's transmitting this advertisement, whether in newspaper or in electronic media or social media, then the person who is making this advertisement, then the one who is endorsing it, for example, the film stars, and then the person who is selling the products. So all these people has been brought into the misleading advertisement category, and now anybody who gives misleading advertisement, anybody can file a complaint against those misleading advertisements. Mediation is another beautiful thing which has been brought into this law. We have never heard of mediation in the consumer protection law because it used to be known as a small cause courts, so it was not existing. But now mediation has been brought. For example, in India there used to be Lots of complaints with regard to the washing or dry cleaning of clothes. When you give your cloth to a dry cleaner, you normally see few conditions are mentioned below the bill. One is errors and omission excused. Then something like there is a delay, it is beyond our control. And the last line used to be that if something goes wrong with your cloth, we shall not be responsible. So they always used to, get rid of that we had already conveyed the consumer. And whatever you said, caveat emptor, that buyer beware, he should not have given. But now that thing has been completely wiped out. The law says if the clause is unreasonable, it will not be considered. So even the agreements which are against the consumers with an intention to cheat them, they will not be considered that they are the genuine documents which has been signed by the consumer, and they will reject that and they will give the relief to the consumer. Now, for this mediation, huge setup or huge infrastructure is required in our country where there has to be mediation rooms. Then they have to make a selection for the people who are supposed to mediate, kind of in every district. So from there, after the mediation, in order to say that it has lot of now strength, we come to the penalties has come, which has imprisonment up to 1 year, 2 year, 5 year. Paucity of time, not going to each section, but for misleading advertisement, you can be put behind bars for 1 year, 2 year. You can be penalized for 10 lakhs, 20 lakhs. And if you don't follow the orders like in the previous law, you can now be sent behind bars. So now that position has also come where for the execution of the order, people can be sent behind the bars. Last in section 8 and 9, there is very important thing called Consumer Protection Council. Now, Consumer Protection Councils are very important, and we have discussed once in Bombay in BHS meet also that every district is supposed to have a Consumer Protection Council for the benefit of the consumers. But it is not being done. It is almost 99% districts are not constituted it. I personally know because in 2016 Chandigarh became the first city in the world to be a service charge free. Earlier, we used to go to eateries and hotels, they used to charge service charges. We challenged them and we found that there is no provision. Then we went to the law and this says Consumer Protection Council can issue a advisory. When we went to see, we came to know that the last Consumer Protection Council was constituted during Chandrasekhar regime when Dr. Swamy was a commerce minister. That was the last in 1992, I think. Now, after 25 years, we constituted that council. That council issued an advisory that these charges cannot be charged. Even then, the things were not stopping. Then we went to the court. The court said there is no law. Then we went back to the government and then we issued an order under 143 prohibitory orders that if somebody will charge, we'll put him behind bars. So with that, this thing ended on 8th of March 2016, and till now, nobody has been able to impose it. With this, my time is also going to go up. So what I say is that caveat emptor, buyer beware, is over. Now it is called caveat venditor. Caveat venditor means seller beware. And before I end, I must say about that Guru Nanak Dev Ji has also said a lot about honesty in the merchant business system. And one of the three major tenets of the Sikhism is uh, Kirt Karni, Naam Japna, Vand Shakna. Kirt Karni means you work hard, you earn, and in Punjabi they say Dasa no adi kamai, means with your 10 fingers what you earn is honesty and rest is useless. I think with these kind of principles, we have spoken enough about it. One line I will say regarding the lawyers that why they have not been brought in right now. The bar councils are having a wonderful mechanism where anybody who's feeling aggrieved from a lawyer for not performing good services, they can immediately move a complaint to the bar council. As of now, the bar council takes it very seriously. And on a lighter note, there are certain, anti-legal groups who ensure that the person against whom a complaint has come, he should be dealt severely. And with this, I will, keeping in view the time, I will put an end to my today's talk. And thank you very much.
Thank you, both of you. Very, very interesting from a different perspective. Um, um, Venkat gave us the philosophy, and you gave the nitty-gritty and made the act something that is comprehensive. Let me ask one question to both of you. Consumer dissatisfaction has been the foundation of this act. So let me ask you, if a politician in an election promises you he'll build a road and doesn't build it, can the Consumer Act empower the voter to go and file a case against him?
In this, what is happening?
First,
Yeah. Yes. Yeah, go
The-
on, Jagga. Then we'll ask Venkat. Yeah.
okay, Jagga,
Yeah.
go ahead.
What we are doing over here, what is happening is that in case of problems, if we go to the consumer court, we have no evidence in writing. But then we have to first go to the RTI. And in the RTI, we ask them, please provide us the copies of the plans if they are there. If those things are there anywhere in the plan and that is not being executed, then I go to the court and then it works. But I must have some document with me which I can tell you with the help of RTI that can be obtained. And if that particular clause is there, from that RTI document, that's an official document stamped, I can go and say that my right, consumer right, is violated, and here is the evidence.
And what will be the punishment for the politician?
So, in fact, the punishment will go to the government.
Okay. Because the government didn't do it, or that the. All right, I understood. I don't want to push this. What about Venkat? What's your philosophical view?
Okay, no, not philosophical, practical view, very down to earth, is that there's absolutely no way any action can lie in those circumstances because it is not a legally binding contract. Now, forget issues of evidence. Let me give you a simpler example. If you had a political party putting it in black and white in the election manifesto, so what more evidence do you need? Almost as a binding promise. There is no way a decent court. Now, I have to add a caveat. It's possible some crackpot judge in India will quite happily take up this case and spin it around. But any decent judge will say, you know what, the solution to this problem, it is a real problem. The solution to this problem is political. That is, boot this party out, boot this politician out at the next available opportunity. That is the only way the law can be kept free from frivolous, vexatious, and time wasting problems of this sort.
Okay. Okay. That is, you give him full 5 years to do further fraud, then you can't bring him to book immediately, but you say, well, you got an opportunity to vote against him next time. Okay, I understand. I was just being trying to take the law to its what I thought was a logical extreme, but you have pointed out this illogical extreme. Okay, Ramesh.
I know, based on Dr. Swamy's question and the partial reply which Mr. Ajay Jagga has given, what
Yes.
Ajay Jagga has interpreted, which I feel I want to discuss it with him, that perhaps a government agency can come under the ambit of the consumer law. I just take an example. Suppose in a development plan, like in the city of Mumbai, there is a development plan every 20 years. And suppose in a development plan of the year, let's take hypothetically year 2000, there was a road shown that this road will come up in this particular area, and it did not come up. After 20 years, in a development plan of 2020, again the road is shown, but is not still likely to come up. So I think one must take, perhaps I want Ajay Jagga to respond, and perhaps Venkat also, that based on some RTI application saying that whether it is true in 2000 there was a proposed road, and again now there is a proposed road. What are the plans for the future? Perhaps a citizen, a tax-paying citizen, can go to a consumer court and perhaps force the government to make that road. I'm just bouncing off this idea to both our friends who are on the panel here.
Yeah, what's the answer?
Does Ajay want
See,
to
as
go
I
first, or
told
can
you,
I jump
Yeah,
in?
Venkat, get in.
Okay, I'll keep it very brief. This is a very different example from the one that was given before. In this case, definitely there'll be a legal action lying. You know what for? It'll actually be an action in administrative law. So it'll be a case of the High Court being able to issue a writ of mandamus, because what is happening there is a breach of statutory duty. If the law says that a certain plot of land has to be used for a certain purpose, in the example you gave to build a road, then if that purpose is not being achieved, then clearly there is dereliction of duty. There is a breach of duty, statutory duty, which can be amenable to
Yeah.
mandamus. In other words,
Yeah.
you go by way of a writ petition. This is not a matter for the consumer court at all. Absolutely not. This is directly a case to be taken to the High Court.
I see.
Sorry,
Okay.
Ajay may have something else to say.
Ajay ji?
yeah, I slightly differ from Dr. Venkat, because for the purpose of roads, for the purpose of bridges, the writ petitions are going regularly in the court. That's okay. What you have said is perfectly all right. But now, since PIL or the class action has come under the consumer protection law, if
Mm.
somebody has bought, suppose 20 people has bought flats in a particular area, we are going to issue the make a road, and people purchased all those flats on the promise of the government, and I paid certain taxes, etc., etc., then I can certainly go to the consumer court and say, okay, look, we have bought these flats on the basis of the promise given by the government that they are going to put a road. Now, since there is no road, I cannot make a use of it. So even a single man can go for the entire society. Earlier, everybody, now even single man can go. So this is, if they are going back on the promise and I make certain investment on saying, so I can certainly go.
Okay, good.
Thank you. Good ideas, or let us try to implement some
Yeah.
of them in maybe
Yeah.
some areas. Ramesh, you
Ramesh?
had a
Yeah,
Yeah.
I'm just picking up a couple of questions from the audience, Dr. Swamy. One is if this is more to do with India, where Uber and all these agencies suddenly do pricing, surge pricing. Is that
Oh.
what is the status of that, Jay?
That surge pricing is completely not acceptable. In
Hmm.
Chandigarh also we had a similar problem in 2019. There is a practical rules framed by every state regarding these cab operators, online cab operators. So there the fare policy is to be given by the government. And in that fare policy, there is one clause that if they want to increase the fare or make any changes, they'll first ask the government. Government will call for public objections, give 3 weeks time, and only after that these fares can be increased. But unfortunately, people are not aware, and these guys are doing it.
Venkat?
Sorry, go ahead, Dr. Swamy. Go ahead.
No, you can also get an opinion from Venkat.
In very broad terms, I would agree with what Ajay has just said, because if there is a policy, and it's very important that there is a policy and not just a vague a document in the form of guidelines, it has to be a firm policy, a legally enforceable policy, because that's where sometimes lawyers get tripped up. Not necessarily in India, because anything goes in India, but if you were to have a strict legal interpretation, what you need is you're actually measuring the action of a certain party, in this case Uber, against a policy which has been breached. Now, if the policy has been breached, then I cannot see why that cannot be made the subject of legal action. But don't forget that a lot of the time these policies are framed in such a way that there is a degree of latitude given, because don't also forget the importance of freedom of contract. So one answer on the part of Uber, if I was Uber's lawyer, I would be arguing that, look, nobody compelled you to to avail my service. You simply, take it or leave it. I mean, obviously, I wouldn't be putting it in those dismissive terms, but there has to be some freedom given to contract. And if it is the case that there is a reasonable basis for surge pricing, then I think a sensible court will uphold it.
No,
Go ahead, Dr. Swamy. Then I'll react to
No,
what.
no, I have nothing.
Okay, now Venkat.
on the search price, if your topic is search, I have a question. But if Ramesh, your
No,
topic
go
is
ahead, Jagdish. You go ahead. I have an observation on what Venkat said, but you can complete. Jagdish, if you don't mind, can you look into the camera? You're looking down, so we're not able to. Yeah, there you go. Yeah.
for example, what is just for the benefit of the viewers and all others, I would just like to say, let's take the case of Uber and Ola taxi service when they have a thing of surge price. When it is raining heavily and there are no transport available outside a railway station, if the auto rickshaw driver or the original Kali Pili taxi was exploiting the public by charging hefty additional price, he is penalized by the traffic police, or if you file a complaint. Just try to understand. A poor taxi driver or a auto rickshaw driver taking advantage of the situation was exploiting the public who, due to heavy rains, is not able to move. So he would say, if you want to, the normal fare is 20 rupees, I will charge you 30 rupees. That would be my interpretation of a surge price, which was not allowed and still not allowed. What has happened now, Ola and Uber, the MBA guys in suit boot have invented this term as surge price. When a common taxi driver or the auto rickshaw driver charges you more, we call him 101 names. But when a suit boot MBA guy uses the word surge prices and exploits the consumer or the user, then I don't know in what sense it is allowed, the surge prices. I'm just posing these two questions to both of y'all, or maybe others have, Dr. Swamy or Paresh Ramesh will. The same thing may happen in an airline. Although today they have a dynamic pricing system that is a little different than surge price. But I know of certain sectors at some stage, for example, Mumbai to Mangalore would cost you 4,000 rupees. But Mangalore to Bangalore, the state capital, would costing 15,000 rupees. It's something like a surge price, SURGE surge price. So that is also exploitation of the consumer. Even if there is a contract or no contract, then what was the MRTP Act, if you recall, in olden days when there was only MTNL, there was a Monopoly Restrictive Trade Practices Act. I don't know. I want the surge, which is a common man surge and a suit boot wala surge.
Okay, go ahead, Venkat. You respond. I just still want to come back to you on what you said earlier.
Jagdish has actually touched a very raw nerve in me, because about 3 or 4 years ago, I had to travel at short notice from, as it happens, Chandigarh to Bombay on Christmas Eve. And do you know what I was told it would cost me on Jet Airways? 62,000 rupees.
Wow.
So it happens. Naturally, I was not best pleased, but I also have to take into account the phenomenon that cannot be wished away, which is supply and demand. That is what actually dictates what is happening. My sympathies are entirely with what Jagdish said. So it's not as if I have any great affection for these Uber and Ola people. It is simply that supply and demand to a large extent determines this. But there has to be some kind of reasonableness, some kind of balance, which is what competition law tries to achieve. And so as long as you have a sensible competition law, and as long as you have even-handed enforcement of that law, then I think you can have some relief. But to a certain extent, surge pricing is inevitable, because when it rains, there is a clear shortage of supply and the demand goes up, and it is difficult to reconcile the two.
Okay, Venkat, I'll just go back to what you said today. What's this word contract? Okay, so when Uber and Ola, let's assume it's in a normal case, so they have a rate and saying that per kilometer is like, let's say 10 rupees per kilometer. I'm just making a number up. Okay, so they say 10 rupees per kilometer. So when there is a demand, how is that increasing in the price? The same. The cost is still the same. Their cost is 8. Let's say the cost is 6 rupees. Just because there is demand, their cost is not increasing. They're only increasing their profit, not the cost. Okay. Number one. No. Let me complete. I want to complete. Second, when they established these rates and all those things, they had a guideline saying that these are some decent rates that you can't do. They can't choose exorbitant rates because they go follow the Protection Act and saying that you can't go and make unreasonable pricing. Surge pricing, I mean, if there is some kind of a law or some kind of a saying that under reasonable conditions you could modify, this seems to be more like, as Jagdish said, the MBA guys sitting there and making fool of themselves because you're desperate to go from a point A to point B and they're just exploiting the situation. Isn't that exploitation?
Yes, it is, and it is something which obviously none of us would endorse. But normally there is a basis for surge pricing. Normally, now
but then it needs to be codified somewhere, right? I mean, let's say in a contract, in Uber's contract online, saying that, hey, this is my contract. If these things happen, there should be conditions as to where the surge pricing will be introduced, not at random things, just because a peak hour surge. That's all nonsense. Because at the end of the day, what happened if Uber introduced surge pricing and Ola did not? Ola would have got more business, but both greedy people, I don't want to use any unparliamentary words here, even though his temptation is very high. So the thing is, if one of them did not offer, he would have got more business. But these bimbos and MBA bimbos in the office thought they could just make more money. But even in the surge pricing, if you ask the Uber driver or the owner, they don't get that much a part of the surge that they get, right? I mean, let's say if they get 90% of the surge money that they're getting is fine, but they don't. So what are these guys sitting in Uber making money? Let's say if it's a 50-50 cut, for what is this 50% that they're getting extra on? So it is exploitation and it's downright illegal. Obviously, the government doesn't want to do anything about it. I mean, in India, it's different. I'll give you one example. Since I work with the agency in New York City, is my customer is Taxi and Limousine Commission. They define the rates, period. The surge, none of this BS works here, okay? They give you a rate and that's it.
Okay, two quick
It is
points.
defined by law. It's codified in law. So if your meter should work, if you don't work, you're fined. Like Jagdish said, the auto guys and Kalipili, taxi walas in Mumbai have a meter. There is no surge pricing in that meter. Whatever it is, it is. You can't Uber cannot make up stuff, nonsense, which doesn't exist. Anyway, I just wanted to make that point. That's all.
Okay, two quick responses. One on why surge pricing. Normally, there is some event which triggers it, and it's usually, for example, heavy rains. Okay, now during those circumstances, again, I'm not justifying this as an across-the-board answer. I'm simply saying that it is not completely irrational. So when it starts raining heavily in a city like Bombay, traffic movement becomes extremely difficult, and that can justify a higher price being charged. But that is just one example. The other, of course, point which I wanted to make, which also, from what you were telling me, on the surface looks like an attractive argument. You know, if you look at the small print of Uber and Ola and all the other service providers, there is very extensive description of the minutiae of circumstances when surge pricing becomes applicable. And there are some contracts which sadly, my fraternity has drawn up, which if you begin to actually ask for a copy, you'll be amazed to find you're given the equivalent of a telephone directory. That is the nature of the regulations and the contract, the small print.
Yeah, I would agree. Your argument of surge pricing is fair and equitable and it's spread across people, not only Uber and Ola. What about the Kalipili taxi wala and the regular auto wala? If you have surge pricing in Mumbai, then they should also be given the power. But what does they get exploited? and only Uber and Ola makes the money and walk away. And second point, Uber and Ola, let's take Uber for example, or because they're more international. Uber's laws or terms and conditions in India are not the same as in the US. If Uber tries this nonsense in America, they'll be sued out of business immediately. I mean, I can guarantee you these search prices nonsense will not work in this country. But just because it's India, they're exploiting. So basically, they just throw something on the website and say, this is my new law. Nobody knows what. Nobody reads terms and conditions. When you buy something, you buy a software, terms and conditions. Who reads all this nonsense? There are 350 pages. It's just accepting when you use iPhone, I agree. What? That's a 350-page document. Who reads that?
Ramesh, if what you say is correct, and I have no reason to doubt you, then the fault actually will have to be thrown at the door of people like Swamy, the politicians who are responsible for such laws.
Okay, Dr. Swamy, you are now accused. So what do you say?
Well, I think what you are trying to say, Ramesh, is to push us into socialism. I don't want that.
I'm not saying socialism. Again, you're misrepresenting my point. My point is very simple. If it needs to be fair and equitable is absolute capitalism.
Yeah, but if there is as I think Venkat also mentioned, if there is a shortage, you mean to say that the prices should be the same when
No,
if
I'm
there's
not saying that.
abundance?
I'm not saying that. I'm not saying if there is a shortage. I'm saying Uber and Ola should not be the only entities that should make the money. I'm making the Ola should make money. The auto wala should also make the money. That's what I'm saying.
That's fair. That's fair. Don't come out when it's raining. There's another philosophy you can have, that if you don't want to pay a high price, then don't come out when.
There needs to be some kind of semblance as to what that surge can be, not exorbitant 300% charge and stuff like that.
The thing is, really in all these things, monitoring is a very important part. You make these laws, and then the guy sits there and said, "No, I've got flu. I got corona. Please keep away," because he doesn't want to service that passenger. What the passenger is going to do? He's going to move on. So I am saying basically this, that somewhere there should be an incentive for somebody to drive a taxi in pouring rain and to leave a passenger somewhere else. So that bonus has to be built into the system. I agree with you that it should not be restricted to only 2-3 companies who have come from abroad and have got money to grease. But at the same time, you can't make it. We can't make micro laws. They have to be macro in character.
Okay, one last thing.
One minute. Has our friend Mr. Ajay Jagga has any comments to make on the surge?
Yes, certainly. Yeah, I have said that there is a fair policy. In that fair policy, there should be a provision, as Mr. Ramesh is saying, then the surge has to be codified. It is not only the rain. It is Valentine's Day, it is up. It is Friday evening, it is up. From what time to what time, no one knows. So the thing is that this is a absolutely gray area. It has to be codified so that one should know what are the laws and how the surge is being implemented. So much so, even now the Indian Railways has started using surge in the Shatabdi trains.
Dynamic pricing.
Yeah, well, I think Ramesh has one point, that the exploitative part should be, somehow the law should be built that the people can't just overcharge. You see, there has to be some way by which in unusual circumstances an extra amount should be able to be charged on the fare, but it can't be exploitative and it can't be discriminatory in the sense some will get it and some won't get it. That part of Ramesh, I agree.
So one thing, I'm telling you, there are tons of questions out there. I'm sorry, guys, I can't get to everything, but I'm just because it's consumer protection. I think there are hundreds of questions. Everybody has their own problems, so I do agree.
Both these speakers have made it very interesting also.
Interesting as well. So two quick questions, rapid questions. So each of you, Ajay and Venkat, you can answer them. Bank failures, I mean NPAs, whatever, because you're not getting, is that consumer protection or is it criminal issue or both?
Yeah, you're talking
Both.
about the victims as what? As customers or
Yes,
as
as
the
victims. Let's as victims.
loan providers?
Yeah, I don't know. Basically the bank's not giving away money. They're giving away my money, right? And they go under and they have NPS, the write-offs. It is impacting me in a way, right? So what happens?
The ordinary customer, the
Yes,
retail
ordinary
customer.
customer. Yeah,
Yeah.
the depositor.
Quite clearly, they can sue for breach of contract straight away.
Okay. The second is what is going around these days. A few right-wing nut jobs have been exploiting, saying that they're going to sell iPhone for like half the price and stuff like that. There's huge controversy going around. A part of these IT cell jokers are also part of it. That people got scammed. So is that, I know that people, like Jagdish and I, we were discussing, saying it's definitely a criminal offense to cheat. It's 420 plus plus. Is there also a consumer angle to it?
That maybe Jagga can talk about.
You see, there is a website called Gamma, Gama.
Mm-hmm.
It is the recent website just launched. It is grievance against misleading advertisements.
Okay.
It is very effective. I have filed one against Reckitt and Coleman. It is working. It has been sent to the group of ministers. So what you just have just now, I said the misleading advertisements are now part of CP Act. And please go to Gamma, or even otherwise anybody can file against a misleading ad, whether 50% off or 20% or 40%, or whether any XYZ kind of a misleading advertisements.
What about statute of limitations?
Standard?
Of limitation of law. Is there a time period for consumer protection? Is like should you file a case within a certain period of time?
No, that is there, but those are not implemented strongly. Yes, there's hardly any limitation issue unless there's something very big. Normally, there is no. Even the Supreme Court has just said now in the case of GST laws that under Article 300 of the Constitution of India, if there is somebody's property, there should be no limitation to recover it. Similarly, if I have been damaged, there should be no limitation to make my recovery.
Okay. And what about NBFCs and cooperative banks? That has been a big issue, right, Jagdishji, in typically getting banks going under depositors?
Yeah, that's a big issue, no doubt, in Bombay and in all over India. In fact, Dr. Swamy is doing a program on the regular Gyan Ganga tomorrow. In fact, Dr.
Yes.
Swamy has gone to the Supreme Court in a PIL that the RBI as a regulator has failed to regulate these various cooperative banks and banks when they are involved in so many NPAs. In fact, tomorrow program of Gyan Ganga will be with Mrs. Suchita Dalal and M.R. Venkatesh and Dr. Swamy on the same issue.
Yeah. Right.
I think we're running out of time. There's so many very valid questions here. I'm sorry, guys. I cannot.
Yeah, running into a minus sector. We are now 9:15. It's been so interesting that everybody's lost track of time.
Yeah,
Okay.
so there's so many questions.
So friends,
Go
okay,
ahead,
friends,
Jagdish.
it was a very interesting episode on the Consumer Act and various aspects of it, but everything has to come to an end in a discussion like this. But a lot of interest has been generated, and we come to the end of this episode. I thank Advocate Ajay Jagga of Chandigarh. I thank Dr. Venkat Iyer. I thank Dr. Swamy for this, all three guests for their thought-provoking discussion. And as you see on the website, as you see on your screen, that gamma.government.in website has been displayed for the benefit of our viewers. So we will be back tomorrow at 8 p.m. Indian time for our regular program, Words of Wisdom, Gyan Ganga, which will be a very interesting episode, as I mentioned, on the failure of RBI to regulate the various NPAs and scams which have been taking place in the financial world. Dr. Swamy's PIL is there in the Supreme Court, and Suchita Dalalji, who has been writing extensively on the subject, and M.R. Venkatesh, who has been articulating his views on various TV channels. They'll be joining us in this program. I do hope you will watch this another interesting episode, which is basically from the point of view of the people, what's happening and how Reserve Bank has been escaping all this. So that we will be having tomorrow. But we will be back on next Saturday for our Saturday Nyay Ganga or legal words of wisdom with Dr. Venkat Iyer and Dr. Swamy. And I wish to tell the viewers that very soon, probably in the month of March, after the legal words of wisdom is over, we will be having a series on the economy for the common man, how to understand the economy for the common man. And that serial will be starting, or episodes will be starting every Saturday, that will replace the legal words of wisdom. So do look in for this another angle or another branch of knowledge by which Virat Hindustan Sangam wish to educate and empower the people. So I thank all our viewers across the globe for their support. I thank my co-host Ramesh Swamy and our technical team led by Ashish Shetty, Vishal Mehta, Ishwar Iyer, Rakesh Gadgi, Tejas, and Swaminathan for their support to put the program together. Dhanyavad, Jai Hind, and good night. Provided which part of the world you are, because this is watched across the globe. It's good night time in India. Thank you. Dhanyavad.
Thank you.